welcome to this Conveyancing Matters chat, which is the February 2023 Conveyancing Matters news. Welcome to Conveyancing Matters with Lorraine and Stu. Join us for a chat about all things property. So, welcome everybody to, unbelievably, the February 2023 Conveyancing Matters news. Can't quite believe we're there already, Stu.
I know, the year's absolutely flying by already, isn't it?
I know, I'm looking at things for Easter and I find it quite shocking. And of course, National Conveyancing Week coming up, the week commencing the 20th of March, isn't it?
That's the one, yeah.
Lots going on for that, and we'll talk to some of our conveyancing friends during that week, no doubt. But come on, Stu, let's kick off the news with a big positive point. What have we been up to?
I suppose blowing our own trumpet. The first thing maybe to bring up on today's news chat would be our Conveyancing Live subscription launch night that we held at the Red Door in Rayleigh, our first sort of launch night in Essex.
Yeah, it was a great venue, wasn't it? I really liked that. So go to the Red Door in Rayleigh in Essex, kids. It's a lovely, lovely venue, and lovely Andrew McCall from AM Surveys and his colleague attended, and they kindly sponsored the event. And I think it was a really good evening. And we'll put out a little video, won't we, Stu, about
little taster,
just to show people what we got up to, and hope that perhaps that some of our subscribers might want to come along to future events. We've got one coming up in now in Birmingham in May. I can't quite believe it's Stu, but yeah, the event was really good, wasn't it?
It certainly was. Yeah, I think everybody had a good time, and hopefully we'll be sort of getting around the country a bit more this year rather than just London, so as many people can attend as possible.
Yeah, absolutely. Oh, well, and continuing the slight Conveyancing Matters trumpet blowing, but our January chat with Mike Harlow, the Deputy Chief Exec from the Land Registry, has really taken off, hasn't it? And there was a lot of traction. A lot of colleagues in the conveyancing industry were kind enough to sort of promote that, and really, Mike saying, well, yes, the Land Registry timeframes aren't great. No, I didn't mean to offend conveyancers when I mentioned requisitions in a blog. And I just like Mike. There were a bit of adverse comment here and there, which people are entitled to make. But what I liked about Mike, Stu, was I just thought he was sort of refreshingly honest.
Yeah, he was very open, wasn't he? Very honest. And, it's such a simple thing that I never really thought of. Was when he made the comment that, we can turn work away, but he can't, can he? He literally has to, complete every application that is sent to him, and he has no control over what's going to be incoming.
Yeah, absolutely. And I can, what was clearly an interesting thing from the Land Registry's perspective, that of course they sort of promoted the chat with us and put that at the top of their own news email to firms, which I think indicated the importance to them of the chat with us. So I was really pleased about that. But of course, to be completely balanced, we can't talk about the Land Registry without mentioning more strikes, which unfortunately the staff feel that they have to sort of carry out. And I mean, unfortunately, really from their perspective rather than anybody else's. But of course, conveyancers at the coalface as well, because that's clearly not going to do anything for the turnaround times, is it, Stu?
Well, it's certainly not going to help. And, even though we had that great chat, we still can't ignore the problem that exists and the fact that it's sort of hurting law firms on a daily basis.
Yeah, absolutely. So what else has caught your eye, Stu?
I think one of the things I found interesting was an article in today's Conveyancer regarding upfront information packs. Now, maybe not that that's a new subject. I think we've all spoken about this many, many times, but there's a particular law firm that's been looking at these packs, working with government, working with their contacts. But the interesting part of the article wasn't necessarily this upfront information. It was more the defective title insurance that they were advocating, I assume, bringing in on all cases if it's upfront information, because they won't know about that case before they receive it. So I think potentially it could open up a can of worms, dare I say.
Yeah, I think so, Stu. I mean, I agree. That's certainly the thing that caught my eye, and you know, and good on them. I mean, you know, I admire anybody for having a go. I have to say, it's a busy market now. Let's be serious. The market is as fragmented as I've ever seen it, as we've talked about before. But yeah, this idea, and I sort of did slightly wonder, well, is this the sort of thin end of the wedge in terms of particularly if government has been involved? I don't know to what extent, but as you say, Stu, if they're looking to include an indemnity insurance policy as a sort of standard with their packs, well, are we edging towards title insurance on all conveyancing? I don't know. That should scare quite a few conveyancers out there, I must say.
Maybe not. I mean, I think this has been something that's been spoke about since the late 90s. Ever since I came into the industry, it was always said it won't be long and there'll be a policy for absolutely everything, just like it is in America. That was the thing that I was told for yonks and yonks and yonks, and of course that's never really taken off, has it? Is there an appetite for that? I don't know.
Yeah, well, interestingly, I felt more enlightened by that when of course we talked last year to Nikki from California, because of course something that, I mean, and it sounds a bit of a trope, a bit of a cliche about the sort of American market, but of course, nothing's that well established. So they haven't got sort of titles laden with complex covenants and easements and all the rest of it. And I mean, at the end of the day, and I'm sure, you know, perhaps we'll invite again one of our sort of indemnity insurance friends on, Stu, but you know, the indemnity insurers in England and Wales aren't in it for fun, and they're not in it, you know, because they're charities, and they can give us £150 policy because the risk is very low. And I suspect that, you know, people have been beavering away looking at title in England and Wales for years, and have probably done the maths and realised that actually the cost of trying to indemnify title defects over here it would be potentially so extraordinary that it wouldn't be commercially worthwhile. That would be my very
I do also think that there must be a lot more detail than we're privy to, because of course, you know, a one-off policy for defective title isn't necessarily going to please your client or your lender. It's not taking into consideration the actual practical part of the issue that might be there. You know, there's always this innuendo, an indemnity policy fixes absolutely everything. Well, of course it doesn't. And, you know, having a defective title policy might not necessarily speed things up and might not be the answer.
No, that's a good point, Stu, actually. And of course, lots more buyers conveyancers now wanting to get their own policies thanks to the Insurance Distribution Directive, that little zinger. You know, and you're absolutely right. And I mean, I always characterise it when I'm training, Stu. An indemnity policy, as you rightly say, doesn't put the problem right. It just gives you a way around the problem. The problem still exists. So I think that's a definite watching brief. I think it's a really interesting point, actually. I should be really interested to see if that gains any traction, I have to say. So good luck to them, really.
Yeah, definitely.
We'll perhaps have a chat to them about it, actually. So, Stu, I thought we'd move on. You know, Japanese knotweed is something that's rarely out the news. And a case a few weeks ago sort of hit all the newspapers because, you know, two, you know, nice middle-class people, a seller and a buyer, bought and sold a house, and knotweed was found hiding behind a bush next to a shed. And basically the buyer sued the seller in misrepresentation and won. But that was in the Central London County Court, I think. But what might have passed people by is that we've actually got a newer, even newer, more recent case from the Court of Appeal on knotweed. So really, Stu, you know, and it was again relating to the tort of nuisance and the extent to which a nuisance claim could be made for knotweed being on a neighbouring property. So in the interests of shameless plugs, just want to really point out to people that actually we will do our March 2023 CPD webinar on the knotweed issues and the issues particularly surrounding, you know, conveyancers at the coalface, Stu, won't we? So that's what our March 2023 CPD webinar for our subscribers will be on.
No, definitely. We've been sort of sparring, I think, with knotweed for a while now as a profession, haven't we? And it's getting to that point now where we're possibly coming for the knockout punch. where it's really going to affect conveyances over the coming year. I mean, I found something interesting about Knotweed myself fairly recently, and I didn't realise it didn't flower in winter. So if you're looking for knotweed at the moment, you won't find it.
That's the problem. That's the problem. If you're buying
Yeah.
a house between sort of October and March, there's just basically no evidence of it, because it literally all dies back, just all under the ground. There's virtually no evidence of it at all.
That's it. And of course, we've also fairly recently been talking about other invasive plants and species, and bamboo and Christ knows what. So we really are moving, I think, knotweed and invasive species to another level now, aren't we? So it's something we're going to try and sort of thrash out in depth in our next chat, aren't we, for our subscription and followers.
Yeah, absolutely. Well, because I think the thing is, we've got two very distinct and completely linked, obviously, sort of points to make, because obviously we now do have a bit of a body of case law. We now do have a very recent Court of Appeal case, and it affects, you guys at the coalface every single day, because it's on the PIF. So there's lots to talk about there. So moving on, Stu, conscious of time and all that, sort of tiny point really that I just want to mention. I mean, the Land Registry very helpfully produces sort of updates on its practice guide and gives us alerts and so on and so forth, which I obviously sort of cast through every month, and really only mention those that I think are of real sort of day-to-day relevance for conveyancers. But they have mentioned a tiny update to Practice Guide 6, which I just think is, anything we can do to prevent a requisition, Stu, is a good thing. And they have mentioned, in relation to Practice Guide 6, which is devolution on death of a registered proprietor, that they've amended to clarify that where a conveyancer's certificate is lodged in support of an application, the certificate must confirm that the grant of probate, letters of administration or court order isn't limited. So if you do, and it would be, the thing is, it would be relatively rare to have a limited grant in the normal sort of grind of day-to-day conveyancing. So it's just one of those sort of slightly quirky things that might catch a conveyancer out. And as I say, anything we can do, Stu, to avoid a requisition 6 months into the application is a good thing. So just to make it clear that if you're giving a certificate in relation to grants of probate, letters of administration or court orders, you do actually have to certify in the conveyancer's certificate that that document isn't limited. That's all I wanted to say. So over to you, Stu.
Yeah, so again, without sort of labouring on this point, we can't really not, mention the Building Safety Act 2022, because it's something really that is sort of, gaining more and more and more momentum. And I think rather than maybe discuss it in depth today, it's another series we're going to do and something else we're going to look at within our next sort of series of events. So we're going to really sort of thrash out the detail in it and give everybody a proper rundown in our sort of April and May subscriber series, aren't we?
Yeah, absolutely. I mean, the lenders are continuing to impose, some of them sort of more and more onerous obligations on conveyancers. And I think a lot of conveyancers actually haven't really started to open their eyes to the issues relating to the Building Safety Act. So, I mean, certainly for the purpose of, our February news, all conveyancers need to be checking the lender's requirements in relation to this, because, a new section to the handbook has been added. So it's very much a watching brief, a very narrow topic. And as you say, we'll talk about it in our CPD videos.
Yeah.
But really sort of linked to that, and I think what's interesting about the potential scope of the Act, Stu, is that, it has been reported the first tier tribunal has made its first remediation contribution order under the Building Safety Act, where basically the first tier tribunal property chamber ordered a landlord to repay amounts paid by leaseholders under service charge, which had been used to put right historic fire safety defects. But I think what's interesting about this, Stu, is that at the moment, I think, and I would, to be honest, say me included in this, I'm not certainly not, sort of suggesting that I'm, bigger and clever than everybody else, quite the contrary. But I think a lot of us still think in terms of the Building Safety Act requirements in relation sort of to cladding. We think about the cladding issues as being, and they, of course, the terrible events of Grenfell were the sort of driver for the production of this frankly really rather grim statute. But I think the interesting thing about the recent case is that the issue didn't relate to cladding; it related to balconies. And I just think conveyancers need to have a sort of a weather eye and an awareness and an understanding, really, that sort of fire safety issues are way beyond cladding. I think is the point, and I think that this whole thing is going to run and run. I mean, you just mentioned that, you know, Japanese knotweed is likely to sort of, you know, go viral, and I suspect, you know, the cost of remediation and what's going to be recovered for sort of fire risk more generally is probably going to go the same direction, really, Stu.
Most definitely, and of course that's why we're going to cover it in depth, aren't we, in the next few
Yeah,
minutes?
absolutely. So a little sort of twiddly point that you've noticed, Stu, but I think very relevant for firms because it affects every single letter that they send out.
Yes, our friends at the Legal Ombudsman. So Leo are making some changes, aren't they? I think it's the 1st of April 2023. There are going to be new timeframes that firms need to adhere to. So it's most definitely worthwhile jumping onto their website. I think they even give you standard templates you can use and whatnot. So definitely, if firms haven't already done so, you need to jump on there, see the changes, see when they're effective from, and make sure, of course, your standard templates are called with what they're saying and what you need to do.
Yeah, absolutely. I mean, I think you know, again, just my personal guess, rather anything more considered, Stu. But yeah, I think part of the driver around the changes to the ombudsman sort of timeframes for making the complaints may well some of that may well feed into their own sort of KPIs and metrics, quite frankly. But they have as you say, come up with guidance which firms should go and look at. Not every conveyancer, but anybody watching this might want to check that firms have changed their, you know, their client care letters, final decision letters, website information. That's all got to be, you know, changed and up and running by the 1st of April. But as you say, Leo has tried to make it easy for firms by including suggested wording for the client care letters. So hopefully it won't be too bad. Well, pushing on, Stu, I just wanted to just sort of remind firms sort of more generally, really, about the sort of vagaries of email, because it's so ubiquitous. We use it every day. And I always think it's just worth just sort of stopping and having a think for a moment when, you know, our higher courts mention anything, because in a recent case, the Court of Appeal, and it's an interesting case for property lawyers more generally, I might do a webinar on it, I suppose, but the Court of Appeal had to decide whether a beneficial interest had been released. And the nub of it was really, in relation to the email sort of comments that the Court of Appeal made, is that the common intention that one of the parties relied on was in an exchange of emails. And basically the Court of Appeal held that it was possible to essentially release an equitable interest by email, because you know, the Law of Property Act requires that a disposition of an equitable interest in land should be made, quote, in writing and signed by the person disposing of the same. And the Court of Appeal had no difficulty, no hesitation in holding that, and an email doing that complied with the statutory formalities. And of course, we had a case not that long ago where it was specifically found against a law firm that actually an exchange of emails with your sort of signatory at the bottom of the email was sort of sufficient to constitute signing. So I just think firms, and clearly, you know, firms aren't going to be writing to their clients saying don't release an equitable interest by email, kids. But I think what firms need to be more aware of is what their staff are saying and doing by email. And I think that's really the wider point. And whether or not firms, for example, want to be thinking about, you know, should they be putting some sort of limitation on emails around the authority that people sending emails have within that firm to enter into contracts, make statements, whatever, because there is a bit of a sort of line of authority on that now, Stu. And it just popped the concerns of emails back into my head, really. And I always think, as I say, when our higher courts comment, we ought to sit up and listen, really. But anyway, And an interesting one again for firms. I think some firms struggle with this, and I'd be interested to know your view from the CLC rather than the SRA side of the fence. But the SRA accounts rules, moving on, have got a requirement, quite rightly, I'd say, the client account mustn't be used as a banking facility. And essentially, the difficulty that some firms seem to have is the interpretation that of the phrase in the accounts rules that payments into and transfers or withdrawals must be made in respect of the delivery of regulated services. So if you're putting client money into and out of your client account, it's got to be in relation to, as I say, in connection with a current file, really. And firms might be, I mean, it was introduced now as far back as 2004, Stu, but firms might be interested to know that the SRA has actually recently put up more guidance about it. And I just think that might be quite helpful for firms, but also staff working within firms. I mean, conveyancing, we have so much money coming in. We have so many requests from clients to send money on completion. That's the big one, isn't it? I mean, what's your view?
Yeah, of course it is. It's the difficulty, of course, is where you're taking instructions from a client, then they ask you to do or make payments, should I say, which may not be exactly relevant to the actual transaction, potentially distributing net sale proceeds, where they're going and for what purpose. That's the difficulty, I think. It's the client's money, so can't you send it to so-and-so and whatnot. So again, I think you could look at it half full or half empty. It does limit the retainer, and it does make it easy for you to rely on something that you don't have to do all this extra work for your client.
Yeah, I think so. I mean, and the SRA have certainly sort of stuck guidance out there and basically said, well, if you're paying on in relation to the net sale proceeds, if you're paying the estate agent, for example, that's absolutely fine with your client's authority, of course, because it's part of the
transaction,
perceived conveyancing process and the transaction. But if your client says to you, can you send part of the net sale proceeds, to Bob's garage to buy him a new car, then the answer to that is no. It should be no, because that's not part of the retainer, that's not part of the delivery of regulated services. And I have to say, I do think one where firms should be very, very careful, not only of the regulatory requirements, but just the risks more generally. Of course, if a client who perhaps is a PR and they've got the grant themselves, who comes to the firm and says, well, here's the list of 10 beneficiaries. Can you send the net sale proceeds to all of these beneficiaries? And I think it's very straightforward. I think the firm should be saying no. It's very, very simple in my view. And there's, let's face it, transactions are long enough now, Stu, that it's we can say to a personal representative client at the beginning of a matter, go and open the executive's bank account. And if they can't or won't do that, and I have anecdotally heard that can sometimes be trickier for people to do. Well, if the money is going to go into the personal representative's own personal bank account, then we probably need to do no more than sort of warn the client of the risk of mixing their own money with that of the estate. But under no circumstances should firms be faffing about paying beneficiaries.
No, well, it wouldn't be under our retainer, would it?
No, that's different if the probate referral came from your probate department, because all you would then do is transfer the net sale proceeds to your firm's probate ledger, and they would distribute it because it's their retainer. But where we don't have that link, and as I say, it's just sort of John Smith that's gone out and got his own grant. The answer I think is very simple: no. But as I say, there's more.
It's the same with repayment of loans, isn't it? If it's a secured loan, obviously, but it's where a client may have other debts, should we say, and there may be discharging those out the net sale proceeds again wouldn't be part of something we should be getting involved in.
No, absolutely not. You're absolutely running the risk of using client account as a banking facility. I just don't see why firms would even want to take the risk of thinking about it. But as I say, for those who are interested, the SRA has stuck out a bit more guidance. And to be honest, I think it's the fact that it's SRA is irrelevant in the sense that I think it would be just general practical application for all firms, including CLC regulated, I have to say. So anything else for you, Stu?
I think there's one final incy-wincy one, isn't there? Which is potentially the use of the fax machine. It's still there, but Nationwide and the Mortgage Works have recently said that they're ceasing communication by fax, aren't they? So we are moving forward maybe to the modern age but still some banks are holding on, but another 2 are gone now. So yeah, hopefully.
Yeah, I mean, it's interesting because, of course, we've talked about this before, Stu, because we crawled back a few years ago to the use of fax because of the cyber risk and the cyber security risk.
The irony. I know.
Say again?
The irony of it.
No. And I actually met a guy who said, well, using fax is as dangerous as using email. I don't know because I'm not a techie. But that was why. I mean, everybody sort of burnt their faxes like, people burnt their bras in the 60s and then had to sort of, go and get that facility again. And I think if lenders stop sending email redemption figures by email, which is the massive risk that we're all trying to mitigate against, and they use sort of proper secure channels, then happy days. But of course, and I know, Stu, that lots of them don't. So it's really...
I think this is where it becomes a bit tricky, isn't it? It kind of seems that from our point of view, we have to use the fax, but from a lender's point of view, they go against their ethos of what they're saying in terms of us communicating with them. So I can never really get my head around why it's okay for a lender to send us a redemption figure, like you say, yet we can't request one, or we can't, do it the same way around. It doesn't really make any logical sense, does it? No.
Well, and as I say, if the perceived risk is relating to cybersecurity and the interception of emails, why is it okay for a lender to send a redemption request by an unencrypted email? I simply fail to understand that.
100%. Yeah, it doesn't make any sense.
And all that is doing is increasing the burden on the conveyancer, who presumably has then got to fiddle around and sit around on the phone to the lender for an absolute age to confirm the details in the unencrypted email that the lender has sent. Now, I could be talking cobblers and there might be something really, strategic going on there, but I can't see it myself. I've got to say.
No, I don't think there is. And it's difficult, isn't it? Because obviously each lender has a different criteria, and that's what makes it a bit tricky when you're trying to deal with numerous completions or exchanges or whatever you're doing, whatnot. And then you've got to evaluate how you communicate with someone.
Yeah, exactly. I mean, I struggle with the disparity. I struggle. You're right. You hit it the nail on the head there, Stu. But I do struggle in the sense with the one rule for us and the one rule for all of you.
Yeah.
Attitude, really.
Because I really thought with LMS and lender exchange that the days of sort of communication via direct email, even or fax, were going to be coming to an end. But it's certainly taken its time, isn't it?
Yeah, exactly. Well, we don't want to finish the February Conveyancing Matters news on a downbeat note, Stu. So let's conclude where we sort of finish where we started, Stu, with another sort of shameless plug for our new Conveyancing Matters subscription service. We've got some lovely people that have joined us, and fundamentally for £40 a year, people can have access to quite a lot of webinars, plus one new webinar a month, one new CPD webinar a month, and if you're a firm, you can have that for £150 a year, and for that, people can also come to our events as well. So what's not to like, Stu? And for anybody watching, we're going to be offering, just sending those people who've been kind enough to join us a little welcome pack. And we've finally got a little bits of merchandise that we're going to put in it. So if any of our subscribers are watching, your welcome pack is coming out soon. So well, thanks for that, Stu.
No problems.
We often get to the end of our chat and think, oh, there was more to talk about than we thought. But maybe that's you and me. So I will see you soon, Stu. Take care now.
Take care. Bye.
Bye.